And welcome. It's Monday, 1 o'clock. Sorry, 1:05. I apologize. Ran into a little traffic and a lot of phone calls this morning, so here we are, a few minutes late, but hopefully it will be worthwhile. I'm still loading up the second computer here, and it's not cooperating with me fully. But I wanted to talk a little bit about small business and what we are going to face in the coming months. 44% of American jobs are held in small business. You are small business people. You each have your independent contractor status, and as such, you face small business challenges every single day. And I want to address that from a standpoint of how we can help our business as well as other small businesses who are going to be suffering for months to come. And so that's kind of where I'm headed with a topic for a bit of today anyway. And again, forgive me if I am, as I'm trying to boot this thing up, running just a tad behind our normal schedule.
I'm gonna hijack this from you down.
That's fine. Okay. First of all, I want to go back to 2008 and talk about the economic collapse which occurred because subprime mortgages were causing home values to be inflated. And as a result, nearly 10 million homeowners lost their homes through foreclosures and short sales over about a 5-year period of time. We saw the peak in 2005 of home values, and from about 2006 to 2008, when the crash occurred, we had already started to see people underwater in their housing, in their mortgages. From 2008 to 2010, we saw a huge number of people who had to file for a foreclosure or had a property foreclosed on them, and went through short sales and all of that. Those of you who lived through that know exactly what I'm talking about. It was a nightmare. The impact was immediate on the real estate market, and it was devastating for a number of years. Today, we have more people unemployed than at any time during our nation, ever, including the Great Depression. In the 1930s, 25% of Americans were unemployed, roughly 30 million people. But our population back then was 125 million. Today, 15 to 20% are unemployed out of 330 million people. 44 to 66 million people are currently out of work. Now, I believe in the safety precautions that we have taken. I hope that they will prevent a second spike, a second wave, as they call it, as America begins to reopen. I sincerely hope that we all remain prudent, follow the rules, and so on. But here's what the numbers don't say. And I think that those of you who have been in the business long enough will agree. What the numbers don't say is how many of those people on the unemployment roster are not independent contractors, because historically, independent contractors have not been able to claim unemployment. And even though the rules state, the game has changed to allow independent contractors to file for unemployment, and some have been successful, others have not, unfortunately. That hasn't been the case. And there are a lot of independent contractors and small business people who simply don't have unemployment. They're not on the unemployment roster. So the number could be considerably higher than the 44 to 66 million, depending on who you look toward as a source. At any rate, it's huge. The number of unemployed people right now is huge. So, why is that important? Why is that real estate important in connection with small business? Well, here's an example. Over the past couple of weeks, I've been painting my garage. Now, I thought I was going to be buying a couple of gallons of paint, some primer, some sander, sanding paper, and so on. Well, I bought primer and paint, sandpaper, brushes, drop cloths. Then I realized I had to buy more primer, caulking, and root beer. See, the little hometown-owned hardware store that I go to has this ice chest thing full of root beer, refrigerator full of root beer, various kind, best root beer there, Sprectors and all sorts of Dog and Suds, if anybody remembers that. So every time I go into the little hardware store where I shop, I buy a bottle of root beer, just because I want to. So I buy all of this stuff, caulking and paint and primer and root beer. And when I got done painting the walls and the trim, I looked at the floor and I realized it looks awful compared to the rest of it, which was quite nice looking by now. So I went back to the store and I bought more paint. I bought degreaser and I bought acid etching and all of the stuff, a big wide squeegee. My little couple of $100 project in painting my garage is probably at least tripled by now. Because now I have to have all new stuff to hang my utensils, and I have to have storage bins and all of that. So I suddenly realized how much this one project, this one home improvement project, contributed to our local economy, and particularly this one store, which is a locally owned hardware store. I know I paid more money than if I had gone to a big box store. And yet I thought, I really need to support the local business here who is trying like heck to survive. You may have noticed Jeff Moore's posts about his takeout orders from his favorite restaurants. I know that he did one from Hancock's and another one from, I think it was Hancock's, maybe it wasn't, but Shots. And I commend him for giving business to those businesses that are struggling to survive. And I encourage all of us to do that with local vendors. It's really, really important that right now, more than ever, we support our local businesses, get out there and spend the money when we're doing a project. If you imagine what housing, how important housing is as it relates to small businesses. When you sell a house or when you're preparing a house for market, what do? You repaint it, you clean it, you stage it, take photographs or have photographs taken. You pay someone to edit those photographs or create a video. You pay to have it redecorated. When you move in, you might get new appliances, for example, or new carpeting. If that doesn't happen in the process of preparing it for market, the new buyer may come along and say, you know, this carpet's a little worn, not exactly the color. After I got done with my painting project, I sat in my living room this morning and I thought, it's time to paint the living room. So I'll be painting the living room, and I'll be going back to my little locally owned hardware store to buy more primer, more paint for the rest of the house. It's really, really important that we understand how important our job is as realtors to the overall economy. It is so essential that we get out there and sell houses. We have to do it in order to help generate business for those small businesses who are suffering and will continue to suffer without our support. So I encourage you to do all of that. And do it safely. Play within the rules. We don't want to see a second wave. Texas opened up pretty much and immediately spiked a second wave. We don't want to see that. And so take precautions. We all understand the importance of our economy doing well and getting back on its feet. And that's going to take a long time. The best we can do as realtors is to get out there and sell houses and help consumers regain some feeling of confidence that they can go out and recarpet their homes, buy new appliances, and all of that sort of thing. So I hope you will support that idea and act on it.
We have one question.
But enough. Whoa, one question. And let me go to the question screen here for a moment.
Pete Westers.
Give me just a second. P. Westers, this time around feels different because there is more money available for those that have filed for unemployment. I think it all depends on how long it takes for everything to open up. Thoughts? Yeah, you're 100% right, Pete. We see it particularly in the number of multiple offers that are being made on what listings we have. If I could beg you to go out and get listings. Listings right now are the name of the game because, as you see, we are seeing multiple offers on houses that are on the market. That tells me that there's pent-up demand. If we didn't have pent-up demand, it would tell me that there's no money to be spent. There is money being spent, as Pete pointed out. There is money. Unlike in 2008, 2009, there was no money there. People were underwater on their houses. They were so cash poor that we recovered very slowly. We could see a rebound in our economy if we help encourage people to spend money on their houses in this case. And I think that you're going to see the auto industry do the same kinds of things with incentives to buy cars now to get their workers back to work and so on. So I guess, yes, Pete, I totally agree with what you're saying. We could see a much less significant economic impact because buyers do have money and they do have demand out there right now. Now, there are going to be some of those who are not going to get employed again soon. That's part of the fact, too. We're seeing some deals crash, some transactions crash, because buyers have lost their jobs. They haven't been put back to work. And I hope dearly that that is a short-term situation. I hope that they will be put back to work or find new employment relatively quickly as our economy rebounds. So, any other questions on that at this point, Dom? I want to move on to another couple of topics here today. Maybe. Got a couple of calls over the weekend that I want to address. Escalation clauses. Again, as we see more and more multiple offers, we are going to see escalation clauses. And one of the questions came up, what is a buyer's protection that an underlying offer will trigger the escalation clause? In other words, if there's an escalation clause, what caused it? And can an escalation clause be completely ignored and have the seller simply counter at the top end of the buyer's escalation, the cap of the escalation? The answer to the second question is yes. If you put in there that the buyer is willing to pay $2,000 more than the next best offer up to a maximum of $180,000, the buyer or the seller has every right to come back and say, price to be $180,000, and not give you an escalation clause to work with. I mean, unless it is written in there. Well, if you look at our escalation clause that we've written for you in .loop that's available to you, it does have that language in there that if the escalation clause is triggered by another offer, the listing agent must provide evidence of that escalation clause offer. They're the one that triggered the offer. So I encourage you again to review the clauses and understand them, because they're there for you and they've been reviewed, they've been passed by our attorney. There's a lot of good information there. So when you're in .loop, if you take a moment and read through the clauses, you'll see what's there and available for you. So again, how do you calculate the final price when an escalation clause includes concessions? That was another question that came up. I believe the number, if I can recall, was $255,000. There was an offer of $255,000 with $5,000 in concessions. Now, the way our escalation clause is worded, it says minus seller's concessions. So the real price on that was $250,000. Not $255,000, which was the face price of the offer, but $250,000 was the net face price of the offer before seller costs, of course, as compared to an offer that was written at $250,000. Now they're both the same. So now you have both offers have an escalation clause, one which doesn't ask for any concessions and one that does. The one that does has a higher price, but when you reduce it with the concessions it requires, it brings it down to the same number of $250,000. Therefore, the escalation clause that didn't ask for seller's concessions, if that was bumped up to $251,000, it was a $1,000 increment. If it was bumped up to $251,000, then that buyer, that would be the price of the final offer. Again, with escalation clauses, we feel it's important that you clarify what the final price is. albeit we have had the opinion by our attorney that that isn't even necessary. If there's an escalation clause out there, it can move up without even telling the buyer what it is. However, that ends up in confusion. And the one thing we really want to do is avoid confusion. So, in one case, a seller has come back and said, the price is $280,000, take it or leave it. It has nothing to do with the escalation clause. That's the seller's counteroffer. And then the buyer can say yes or no. The other case, the seller concession was a net offer after concessions as compared to one that didn't ask for concessions, and the increment was $1,000, making it $251, and they expressed that on the contract. Make sure, in order to avoid a lawsuit later, make sure that everybody understands in writing what the final sales price is. We came up with a couple of questions about the COVID-19 addendum versus some of the clauses that we have written for you. From the very beginning of the Michigan Realtors distribution of the addendum for COVID-19, Five Star expressed some concern about the broadness and vagueness of the COVID-19 addendum. We provided some language to you, again, in the clauses section, which helped to clarify and be more specific and provide consequences during the COVID-19 addendum. Now we're kind of seeing the COVID-19 crisis. Now we're seeing the impact of the Michigan Realtors addendum and its, as we said, broadness and vagueness. What constitutes the end of the crisis? Is it the stay-at-home order? Is it the elimination of the federal guidelines? What is it? Well, there's no definition to it. That's why we feel it's important to be specific. One case in particular was supposed to close on April 30th. If you read the COVID-19 addendum, it says, but no later than, in this case, 14 days after the initial COVID-19 addendum was signed, roughly April 30th. We're now at April 18th. I'm sorry, May. Thank you, Tom. May. We're now at May 18th. Nearly 3 weeks after the end date of the contract, according to the COVID-19 addendum. Where was the seller in that period of time? Did they terminate the contract? Did they make any attempt to stop the contract and put the house back on the market? If they didn't, then a court could see it as kicking the can down the road. I think that's a term that most of you have heard from me, that if the seller doesn't take action when a buyer is unable to close by the end of the contract, if the seller doesn't take action to terminate the contract and to put the house back on the market, if they just allow things to proceed in hopes that it's going to go to a closing, that can be perceived as kicking the can down the road. And a court is going to look at that as if they were both acting in good faith, that they're both staying into the contract for a reason. And so when you get into that situation where a deadline is going to pass for the end of the contract, you have a determination to make with your seller. What do you want to do about this? Do you want to kick the can down the road? Do you want to extend it either with an addendum or simply by not terminating? Or do you want to say, okay, this is the end, we're going to terminate, and then we're going to be able to put the house back on the market. When you get into those situations, call me or Eric and we'll or Kim, and we'll walk you through it.
We have a couple questions, if you want to go and check those.
Let's see the questions. Gary Rivera. Sold a house to my daughter. She just took possession today. There were 15 other offers, so we did not do inspections. She's a home renovator, so she knows what to look for. This home she plans to live in, with all this rain, she discovered there is a fresh leak in the roof and some water in the basement. These leaks were not disclosed on the seller's disclosure form. Do we have any recourse? Maybe. I presume, I'm looking at this to see if in fact she closed on the property. Did I miss that? Oh yeah, took possession today. Okay. If it was not disclosed on the property and your daughter feels as though she was misled by the seller's disclosure form, and you can prove that if you have neighbors, if there are neighbors who have known of this water problem and were aware of it and can provide that information, then you may have cause to go after the seller for some remedy. Obviously, having inspections is an important process, and I understand in a 15 offer competition, that's not sweetening the deal by not having inspections. Also gives up some rights when it comes to taking the matter to court, because the first thing a judge is going to ask is, did you have inspections, and why didn't you have inspections? And the answer obviously is going to be, well, we wanted to make our offer better, but we didn't know that there was any water problem because the buyer or the seller didn't disclose it. Is there recourse? Maybe, and maybe not. I think it would certainly be worth pursuing to get a clear answer. Julie Reisner, is the Michigan Realtors form acceptable for inspectors? Michigan Realtors form is not about inspectors. It's about sellers indemnifying realtors and inspectors and so on from against lawsuits that because they allowed people into their house. Likewise, the buyer's Michigan Realtor form is buyers indemnifying the seller and inspector and realtors from anything resulting from them showing them a house. There was a form created by the Grand Rapids Association of Realtors for inspectors to use to obtain permission from the seller, the protocols the seller required for an inspection, and for the buyer to sign an agreement that the inspector was going to be in control of that inspection process, and that we were going to have, realtors were going to have nothing to do with that. So we have all sorts of forms, but I don't recall, and if I missed it, please let me know. I know that there are a lot of inspectors. I know house masters, and another one, I can't remember the name off the top of my head, but both of them have their own forms that they sign, providing them indemnification. I think that one of the things that we have kept attempting to stress in this period of time is that we don't want our fingerprints on the inspection process. That is between the inspector, and the buyer and the seller. The buyer should be ordering the inspections from the inspector, reviewing those forms that they are asked to sign. The seller should be reviewing the forms that the inspector is providing and saying, yes, is this okay? We shouldn't be overseeing that process because it is the inspector's responsibility, the inspector's sole responsibility, to regulate and protect those protocols that the seller requires. And yes, we're not attorneys, so I don't want to be the one to advise whether or not an inspector's form is appropriate for a seller or a buyer to sign. If the buyer or seller feels uncomfortable about signing that inspector's form, I would refer it to an attorney. I would say, this is probably something you should have your attorney review. Any more questions before I go back?
No.
Okay. Last thing. I got a question about a low appraisal, asking what the consequences to the buyer would be if the seller decided to not do a repair required by a lender. There was a $20,000 repair that was required as a result of the appraiser going in just before closing, close to closing. And the bottom line is that if that repair was discovered and the mortgage was not going to be approved as a result of that repair not being done, then the buyer has every right to walk. In fact, the case could be made that the buyer could walk regardless of whether that seller agreed to do that repair or not, because ultimately the mortgage underwriter is going to say, we're not going to give you this loan based on knowing that you're going to walk into a $20,000 repair. So then the question was, well, what if the buyer or the seller changes their mind 2 days from now and they decide to do the repair? Well, now you've got a legal question. If there is no harm, if they have satisfied the terms of the underwriter's requirement, are they going to grant the mortgage? If they grant the mortgage, then it can move forward. However, what happens if the buyer who says, I don't think I want the house now, what do I do now that I have this addendum? I would get a denial letter from the mortgage company and then submit a termination addendum and a mutual release. And again, I know we've said this before, but it's really important to do it on multiple forms, because within the inspection period, for example, within the inspection contingency, a buyer can terminate unilaterally. They don't need the seller's acceptance of that addendum. However, they do need the acceptance on a mutual release. So if you only send the mutual release, technically that contract is not dead until all parties sign it. But if you have an addendum separate, it could be held that it would that would suffice in terminating the contract. So here you've got a seller or a buyer who says, you know what, there's a $20,000 repair required. I'm not going to pay for it. I'm not going to get a mortgage as a result. I'm going to get a termination or a denial letter, and I'm going to write a termination addendum and submit it to the seller and saying the deal is dead. Now, if 2 days later, the seller says, well, I've changed my mind, I'll do the repair. Well, too bad. The deal's dead. The mortgage company denied the mortgage based on the fact that you were unwilling to do the repair. So, again, That's a non-attorney opinion, but I think that the seller would have a real hard time getting any compensation, finding any damages with a buyer who terminated the contract based on a flaw in the property that was identified during the appraisal. So,
Wait, there are a couple questions.
Couple questions.
Follow up for Julie's, she asked. And another question from someone else.
Can you put Julie's question back up? Her first question.
Yes.
Hold on, I'm going to answer Julie's question here in just a second. Okay, how does that get managed because I'm the one pushing the paper? Well, what I have been encouraging is that Five Star doesn't push the paper for the inspector. Our job, as I see it, is to get the seller's addendum signed to the listing contract from the Michigan Realtors that deals with indemnification for the agents and those involved. That's our job. That's the paper we should be pushing. And the paper we should be pushing for the buyer is that same Michigan Realtors addendum, which provides indemnification. That has to deal with the realtors. The issues regarding the inspection are the inspection company's responsibility. If you want to become involved in that at all, I would limit it to the review of those documents and advise your seller or buyer accordingly if you have some concerns about it. For example, if I got a form from Housemasters, for example, and I've reviewed theirs and I don't have a problem with it, just not picking on Housemasters. But if I did have a problem with it, I would say to my buyer or my seller, hey, I've got a problem with this language. I encourage you to consult your attorney before you sign this. Or we've had some situations where the addendum that Five Star created for use by inspectors. It was for use by inspectors, not for our specific use, but for inspectors to distribute it when they were doing inspections. There were some situations where buyers or sellers felt uncomfortable with a particular line in the form. And we said, cross it off or write it under exceptions that line doesn't apply. Again, I would say that if you're going to become involved in the inspector's form that the inspector is to use for the seller and the buyer, and you have some concerns, share it with your client, whether it's a seller or a buyer, and say, I don't like this word. How do you feel about that? You're certainly welcome to consult with them on that. I hope that helps. Basement, Daniel Dick, basement water question. We flipped a house 4 months ago. We disclosed a leak in the basement that had been on the prior seller's disclosure. We did a repair we thought had fixed the leak and stated that in the disclosure. The basement leaked again recently in a heavy rain. Are we liable to fix this leak? Maybe. I can give you no better answer than that. If you stated that there was a leak and that you fixed it, you believed that you fixed it, you've disclosed honestly. The fact that the leak occurred again recently in a heavy rain. Well, we had a pretty good steady rain over this weekend, and I imagine that there are basements that have water in them that don't normally, that have maybe even never had it before. We are seeing high water tables, as we have noticed, for a couple of years now. So I would say a court could look at that and say, they disclosed to you that there was a water problem. They thought they fixed it. That was disclosure to the best of their knowledge. On the other hand, they might look at it and go, well, you said you fixed it, but you actually didn't. I don't know which way it would go. I would say if there's a way that it can be inexpensively remedied, I'd probably try to make it go away rather than have it end up in court, because courtrooms tend to get really, really expensive. So I hope that helps. Okay. Any other questions, Dom? Thank you for being here. Again, even though we started a little bit late, we went a little bit longer than usual. So again, thanks for joining, and we'll see you next week.